What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
Welcome back to the Zona Law podcast. I am Mark Zinman, joined here today with Scott Baluha.
Good afternoon, Mark. Great to be here again.
It is always fun to have a little podcast action. We are here today on part 3 of a 5-part series for fair housing. What's part 3 look like today?
Oh, well, today we're going to be talking about the exciting world of resident applications and a lot of the changes that have occurred in the past. Most notably, a change that had occurred back in 2016 with a HUD memo. What did that guidance give us?
Sure. So it's important, just the biggest overview possible, right? In history, a lot of times we had just a complete ban on felons in our industry. And in 2016, HUD came out and said that's discriminatory. It can have a disparate impact on certain protected classes of race and national origin. So you can't do that anymore. And so you have to have a staggered, tiered system when looking at crimes. Basically, what it requires is a written policy saying what crimes and how far back you can go. So what's the general overview? What are we looking for?
So, one, you're going to be looking for the distance in time that you were either that the applicant was released from incarceration or released from a term of probation. You'll also be looking at the severity of the crime as well. Generally, you're not going to treat somebody that ended up being incarcerated for aggravated assault the same way that you would treat somebody that had been incarcerated or otherwise issued probation for a DUI, which is also sometimes very fact-dependent depending on what type of community that you live in. Some communities are 55 plus, some are all ages. There's all those different considerations that need to be taken in.
Yeah, so under that 2016 HUD memo, you have to have a written policy setting forth whatever tiered system you have. And so you have to look to the nature of the crime and how long ago it was committed, or since they were released, obviously, and figure it out. So different types of crimes, there's different standards, for example, misdemeanors and felonies, but also the nature of the crime. For example, if you have somebody that's a DUI, the chance of them having that same problem on a property and it affecting other residents, pretty low.
Right.
But a crime such as a felony assault, that's something you'd want to have for a much farther time out because, again, that's a much more serious consideration and that's much more concern for the neighboring residents as well.
Right, and also we have to contemplate, well, is there anything out there that we can permanently disqualify? Because one of the questions that we frequently get is, well, we had an applicant that has a registration as a lifetime sex offender. What would we do in those circumstances? Is there any guidance when it comes to whom we can permanently disqualify?
Yeah, so there's not a lot of guidance, but registered sex offenders are one of those people that could still be a permanent ban as long as they have a lifetime registration, right? Because that's an undue burden on the landlord. If they come in and you allow them in under any sort of standards, they're going to get posted with obviously the notice of sex offender moving in, and as well as every other door in your community. Your other tenants are not going to be happy about that, so you don't have to allow that. Additionally, the Fair Housing Act in it specifically says if somebody has been convicted for a controlled substance, the production or distribution of controlled substance, that's a lifetime ban on them as well. Anybody else, you have to put into this standard. Now, what people always ask, like, what the years are. Is it like 15, 20 years? Well, that's not really reasonable a time period. Now, in that 2016 memo, HUD came out and basically says they looked at statistics, and after somebody's been out for 7 years and has not committed another crime, their recidivism rate, meaning the chance they're going to do it again, goes back to 0, meaning no different than anybody else in the population.
And that's an incredibly important point because one of the pieces of pushback that we often get when we explain the no felons rule or that there are only certain limitations when it comes to whom you can restrict coming into the community is, well, look, if this individual was convicted of homicide 20 years ago, I'm certain that I'm going to have my other neighbors and other residents complaining that they have this individual with this criminal background. But as Mark said, if you look to a 7-year period of time, the chances of recidivism are very low.
Yeah, and that's why it's critical you go the date of release, not necessarily the date of conviction. Because if somebody convicted a murder 20 years ago and they've been in jail until a week ago, they just get out. Well, yeah, they haven't committed a crime in over 20 years because they've been in jail. That doesn't count for the purpose of the clock. The clock starts from when they get out of jail or fulfill the probation or whatever the standard is for their crime. Now, we've been talking about crimes, though, but how does arrests work?
Well, arrests work a little bit differently in so much that you essentially are going to ignore those for the purposes of evaluating them under your criminal background standards. Essentially, we don't want to punish people just as we don't in the criminal justice system unless they've been proven guilty or at the very least until they've been started to be processed through the court system, which is how we kind of segue into, well, what if not only arrested, but also that they have charges that are pending? What do we do in that circumstance?
Yeah, so with an arrest, you just say, okay, well, that's an arrest. Anybody can be arrested. It doesn't mean anything. Like you said, innocent, proven guilty. So you don't look into that. If you're doing a background check and that shows up, you just simply ignore it. It's not relevant. I think it changes, though, like you mentioned, when you hit the point of somebody's actually has a pending case against them. They've been charged. They're waiting for a trial. And let's give the example of a sex offender, right? They haven't actually been convicted yet, but maybe they're going to trial in 2 weeks, and they're applying at your property today. I don't think with that you have to approve them. Even though there's been no conviction yet, you can what I would do is do a conditional rejection, right? Conditional denial saying, look, you've got this case pending. Assuming you get convicted, you'd be denied. Therefore, we're going to conditionally deny you. If, however, you get exonerated, if the case is dismissed against you, come back and we'll absolutely approve you. Everything else looks good.
Absolutely, because we want to be as conservative as possible when it comes to when rejecting somebody, because that's typically where your fair housing complaints are going to come from. If there is a violation and you've denied somebody wrongfully, then there's a possibility that a complaint could be filed, and that's what we're trying to help avoid happening.
So imagine you create up this standard. You say, you know what, it's 3 years for a DUI, it's 7 years, which is for the worst on the felony aggravated assault. The HUD memo also requires, though, that you tell the tenant, the resident, the applicant in writing that they also have a chance to present mitigating evidence. What does that even mean?
So mitigating evidence, essentially what that is yes, I was convicted of a crime. Yes, I was incarcerated or I served a term of probation, but I did X, Y, and Z or other things that maybe the community should take into consideration in evaluating the application. Because remember, we have to evaluate each application individually. We can't always bundle everything into certain categories or headings. So for example, let's say that somebody was convicted of possession of a dangerous drug, right? And then they provide mitigating evidence that since their release, they went through not only drug treatment programs, but they became a licensed counselor. They've been a licensed counselor for substance abuse for several years. Are you going to want to evaluate that evidence on that individualized basis?
Well, I like bright line rules. I'm an attorney, so no. I mean, the easier the rule is, the better it is for us to advise. But yes, that's the surprising part about what HUD's decision was in their memo, was basically like, oh, well, you must look at these factors and then make a one-on-one determination, which to me as an attorney is just a whole litany of problems with it. But that's now the standard. And so the most extreme examples, because obviously we're attorneys, you take any issue to the extreme, and that's where you get your answer. Is imagine somebody that you had that shows up to your property and applies, and they're a sex offender. Not registered, but they're at a history, they've been convicted of it before for statutory rape. Well, it turns out they were 19, the person they were with was 17, and that's convicted of statutory rape in certain states. So they've been convicted of statutory rape. Well, it turns out they're coming to you 25 years later, they married that person, they have 3 kids. There's a difference between that type of sex offender and somebody that's maybe a lifetime registration. And that's what HUD wants to look at. So there are times when you look to those mitigating factors, but the biggest thing for me, at least from the rule, is you have to tell somebody they have that right to redo it. If somebody comes in with the mitigating factors, though, Scott, what do you do with it?
Well, I always try to remove the on-sites or the people that have the front-facing with the applicant from making those types of determinations. Ideally, even with mitigating circumstances or the application on the front end, you're going to want to have a third party screen and run and do the criminal background check. Most of them can do nationwide searches in order to determine, because if you're not from Arizona, it's a little bit more difficult to find that information. But you're going to want a third party to evaluate that and make their own independent decision on it rather than allowing the on-site. What's the reason that you don't want somebody that's front-facing making that decision?
The more objective your standards are, the better, right? Like if you take in an application, I, as your attorney, should be able to look at your application standard and look at the application and say the person qualified or didn't. You meeting them should not be relevant at all. And so if you have a background company doing that for you, if you have somebody corporate doing that for you, it takes any subjective issues out of it, and it's literally just based on what's on paper. And then the same applies with the mitigation as well.
Correct. And another important portion of this as well is when it comes to the applications themselves, make sure that those applications are filled out completely. In most applications, there's going to be a requirement to say whether or not you've been convicted of any types of crimes, but it will also ask, and please provide the details. And that's where sometimes there's important information that you're going to end up finding out about that applicant. And also, you want to find out whether or not that information is going to match the public searches that the third party does or that you do to try to make sure that the application is completed truthfully.
Yeah, so our perfect way of looking at that, if that actually even exists, I still haven't found that anywhere, but basically is ahead of time, have a written standard setting out what years to what crimes. Generally, my position is, except for those exceptions, you don't go past 7 years because that's HUD's kind of hint at what is the appropriate standard. Then, as people come in, ideally have a background company run it for you, right? You get the application, you send it into a background company, they do the check. If the person's denied, they have that chance to get mitigating evidence, submit a form, whatever they need to do. Then you give that to your corporate employee, who then maybe it's your regional, maybe it's somebody in HR that handles that for you, and they review the mitigation.
Right, and an important point associated with that, Mark, is you pointed out that that hints to what HUD would find acceptable. This is always going to be a flexible standard, so oftentimes it always comes with a little asterisk next to it, subject to change, subject to future HUD guidance. But usually having those standards where it has 7 years, depending on the severity and the length of time since the release from probation or incarceration, those are our best guesses as to where we are right now in the status of the law.
Yeah, and I think that uncertainty is what caused so much concern back in 26 when this passed, is that everyone was like, oh my God, we're going to a whole new thing. Where, of course, as attorneys, we like a bright line rule, which is you were a felon before, we're never going to allow you. Well, we're past that now. That's not going to ever be an acceptable standard anymore. And what we tried to advise clients through this whole time is that employment laws changed actually way back in 2012. They'd been doing this for years where you couldn't apply that same kind of standard. And it took them a couple years to get into the residential side of things. So I haven't seen any huge issue of problems really since this came out. Have you?
No. And I think as people update their rental documentation, as they go through a process of updating their application process for residents, as this becomes more, well known, then it becomes easier to try to implement as well. But I certainly haven't seen any pushback when it comes to raising those issues.
Yeah. If nothing else, that's a good sales plug. If you guys ever need anything with your rental documentation or updating to make sure you're compliant on what's going on out in the law, always feel free to give us a call at Zona Law. And until then, we'll see you at the Zona Law podcast.